is in public session. I'd like to welcome the Minister for Employment Affairs and Social Protection, Regina Doherty TD, and your officials to this meeting this morning for consideration of Social Welfare, Pensions and Civil Registration Bill 2018. The bill was referred to Select Committee by Dáil Éireann on the 14th of November. Just before we commence, hold your horses. Before we commence, from the point of view of substitutes, Deputy Tom Neville is replacing at this stage Deputy Maria Bailey. And if any other substitutes occur during the course of the meeting, please notify the clerk from the point of view of voting and so forth. We'll commence with the bill and we'll go through it section by section, and we'll take the amendments as they arise to the particular section. In section 1 there were no amendments to it, so that section 1 stand part of the bill is we'll get.
Sorry, Carey, yeah, there was a number of them ruled out, so I'm not sure as to whether you're going to take them now or as they arrive.
As they arrive, as we get to them. Okay. So section 1 there were no amendments, and I'm saying putting it that section 1 stand part of the bill. Is that agreed? Agreed. Section 2 there were no amendments, that section 2 stand part of the bill. Is that agreed? Section 3 with no amendments, that stand part of the bill. Agreed. Section 4 that stand no amendments also, that section 4 stands part of the bill. Agreed. Section 5 was Amendment 1 in the name of Deputy O'Dea. It was ruled out of order. That section 5 stand part of the bill. Agreed. Section 6 Amendment 2 in the name of Deputy O'Dea was also ruled out of order. Does section 6 stand part of the bill?
Can I just make a brief comment on
it's out of order, but you can, yes.
Yeah, but on those set of amendments where I sought to bring it back from March to January, I'm quite aware that these amendments are out of order as a charge in the Exchequer. I merely put them down to highlight the fact that there's a basic inequity there, that the budget provides for tax reductions, tax concessions. It also provides for social welfare increases. The tax concessions kick in January. The social welfare increases don't kick in until March. That seems to be basically inequitable. I know the Minister will probably respond by saying that the last increase of a fiver only runs out in March, and so therefore it's taken over from March. But of course it comes into the reckoning for the estimates for 2020. So what you're doing is you're holding back an increase for people in receipt of social protection. You're holding it back until March, but it will be counted in next year's estimates anyway. It's just simply it's simply deferring the cost out further. And I think we've now arrived at the stage where the tax concessions and social welfare increases should kick in at the same time.
Thank you, Deputy Minister. Do you want to comment? I know the amendment's out of order, but do you want to comment on?
Yeah, just I suppose to acknowledge what the Deputy is saying is factual, but given that he was party, or his party was party to the negotiations of the budget, I think he's well aware of what we attempted to do was to try and spread a finite amount of money to as many people as we potentially could, which is why we arrived at the agreed budget that's before the House.
The reality is that the actual increase, I mean, we were negotiating the budget. That didn't mean that we wrote the budget. We got as many concessions as we could. And the reality is that for your average person on social welfare, the increase is about $3.80 per week, not a fiver a week, $3.80 per week. That's the reality.
Deputy, that section 7 of the bill stand part of the bill. Is that agreed?
Agreed.
Section 8, no amendments. That section 8 stand part of the bill.
Agreed.
Section 9, Amendment 4 is in the name of the Minister. 4, 7 and 8 are related. 4 and 7 are consequential on 8. So we'll discuss 4, 7 and 8 together. Minister.
Oh, yeah?
Amendment 4.
Sorry, Chair. In the ordinary course, the claimant must have 520 full-rate social insurance contributions paid, typically Class A PRSI contributions in the private sector, or Class S if you are self-employed, in order to qualify for the state pension contributory. However, the Social Welfare Act provides that claimants who have at least 260 but less than 520 full-rate social insurance contributions paid, but who also have paid modified rate contributions, may be assessed for what's known as mixed insurance pension. Modified rate social insurance contributions are PRSI contributions at classes B, C and D, and they are typically public servants. In practical terms, Chair, the mixed insurance SPC will typically enable people who have worked both in the public and the private sector or in self-employment to secure a reduced state rate contributory pension to supplement the public sector pension. The amendments I'm introducing here are designed to ensure that the wider provisions of Section 9 of the Bill, providing for the introduction of aggregated contributions methods, are extended to pensioners who have state pension contributory based on mixed insurance records. Such pensioners will consequently be also in a position to benefit in those instances where they can demonstrate an entitlement to home caring periods.
Anybody want to contribute? Thank you, Minister. So, Amendment 4, that the amendment be made, is that agreed? Agreed. Amendment 5 in the name of Deputy Brewin is out of order. And Amendment 6 in the name of Deputy Brewin is also out of order. Amendment 7 we've already just discussed with Amendment 4 in the name of the Minister. That the amendment be made. Minister?
I move.
Is that agreed?
Agreed.
Agreed. Amendment 8 in the name of the Minister, that the amendment be made.
I move.
Agreed.
Agreed.
And Section 9, Amendment 9 in the name of Deputies Bríd Smith, Gino Kenny and Boyd Barrett. They're not here to move it, so that amendment falls. That Section 9 is done part of the bill, is that agreed?
Agreed.
Okay. Amendment 10 in the names of Deputy Bríd Smith, Gino Kenny and Boyd Barrett. 10 and 11 are related, but there's nobody here to move them.
There is 11.
Oh, we're on 10 first.
Sorry. Okay.
Yeah. So Section 10 stand part of the bill, is that agreed?
Agreed.
Okay. Section 11, Amendment 11 in the name of Deputy Brady.
Yep. Okay, here, look, this is just seeking a report to be laid before the House of the Oireachtas on the financial and the social effects relating to the discriminatory cuts for our young unemployed people. And that needs to be carried out because we know that the impact it's having. You know, and time again, the Minister denies it's having any impact, but yet all the evidence from all the organisations out there representing young people, you know, they cite the poverty levels that these cuts are impacting on our young people, the homeless stats, and all of the NGOs are pointing that these discriminatory cuts are, you know, adding to all of that. So it's about time these are reversed, you know, and I've called on the Minister time and time, and again to do that. Unfortunately, my hands are tied. We can't bring forward any amendments that will actually have a costing on the state, but we need a report, because I firmly believe that report will show quite clearly that these cuts that were brought in when youth unemployment was about 24%, it's down to about 12 now. So, you know, they're not having the impact that the Minister will cite time and time, and again, and last week in the Dáil, she said in the chamber, you know, she doesn't want to see our young unemployed people sitting at home watching Judge Judy. I don't think any young people watch that programme, by the way, Minister, but you know, I don't think they want to sit at home either. It's having a real impact, and I welcome the fact that Willie O'Dea, Deputy O'Dea, now has started to raise concerns around this, even though we know it was Fianna Fáil that started the discriminatory cuts on our young unemployed people. So, you know, I would hope I would have the full support of the committee in actually seeking this report that will have a look at all of those core issues, you know, around poverty, around homelessness, that these discriminatory cuts are actually, you know, impacting and adding for the difficulties for our young unemployed people.
Thank you, Deputy Brady. Minister.
Chair, I think as the members of the committee will know that in line with other EU and OECD countries, reduced rates for job seekers were introduced, the Deputy is right, indeed by the Fianna Fáil government in 2009 to tackle high unemployment. The measures were guarded against the development of long-term welfare dependency by providing job seekers with a strong financial incentive to actually engage in either education, in training or indeed employment opportunities. The Department is already finalising a report examining the impact on the reduced payment rates for job seekers between the ages of 18 and 25, as we already committed to under the Pathways to Work 2016-2020 initiative. And as part of this process, the Department is also considering the contents of research undertaken by the National University of Ireland in Maynooth, which I understand will be published shortly in the Journal of Human Resources. That research examined the effectiveness of the reduced rates in encouraging job seekers to avail of education, training and employment opportunities and programmes. The university examined the data for 18 to 19-year-olds as the reduced rates were first introduced for those age categories, and the findings found very positive results, noting an overall reduction in the unemployment durations. So the ambition of Fianna Fáil and the continued ambition of this government to assist our young people into education, training and employment opportunities is working. And indeed, I think the number or the reduced percentage rates of our young people on long-term unemployment backs that up. So I'd be minded, I suppose, not to put this in legislation, but to also point out that there is a report that's being prepared and already committed to, so that doesn't need to be reinstated or restated in legislation again.
I noticed that.
Well,
No, Deputy O'Dea first, and then Deputy Brady.
Yeah, I noticed Deputy Brady couldn't resist the temptation to mention Fianna Fáil. I wonder if we didn't exist, who would he talk about? The fact of the matter,
Deputy Brady, don't rise.
Just to put the thing in its full context now. As far as I am aware, in many countries throughout the OECD, you have a differential between the rates paid to people under a certain age and over a certain age. That's a fact. So I suppose back in 2010, when those changes were made, we were just coming into line with international practice, including, I might add, practice in the UK, including Northern Ireland, where Deputy Brady's party presided over that system, when they condescended to sign up to government for a number of years. In any case, the fact of the matter was that, yes, of course, the initial differential was introduced by a Fianna Fáil government, Fianna Fáil-led government, back in 2010. The difference, I can't recall the actual figures at the time, but the difference was quite marginal. It has been widened considerably since. And the Minister mentions the rationale for it. Well, there was a robust debate on the matter at the time, as will be shown in due course of time when cabinet minutes are released, etc., etc. But you know, I just wonder. About the Minister says that the wisdom of the policy is proved by the actual results. I don't think it's necessarily a case of cause and effect here. I mean, one has to ask oneself the question is, if this change hadn't been introduced at all, would we be in the same position, roughly, employment-wise, youth employment-wise, as we are today? So there's no definite proof of that, and that's what Deputy Brady is trying to ascertain in his amendment, as far as I know. You want to study to see whether this has had the desired impact and what sort of downside consequences it has had, because there's always got to be downside consequences when you cut social welfare benefits to whomever. Now, I'm not totally convinced that you know, I'm mindful of the arguments put forward at the time. I'm not totally convinced that the policy actually achieved the results which it was brought in to achieve. That was the policy that achieved them. I mean, we're hopefully we're at a record low rate of youth unemployment now, but whether that policy has had anything to do with it, I don't know. But my understanding from the Minister's reply, anyway, to bring the matter up to date, my understanding from the Minister's reply is, my understanding, and correct me if I'm wrong, my understanding from your reply is that you're doing this anyway. You're doing this anyway. So.
I'm not. Sorry, Chair.
Minister, let Deputy Brady in first, and Deputy Brady.
Yeah, I'm sorry. I'm sorry. That's what I thought you said, but if you could clarify that.
Minister, Deputy Brady had indicated, and Deputy Brady, you might also comment specifically whether you're pressing the motion in line with the comments made by the Minister that she's already doing a report. Yeah. Deputy Brady.
Well, I will be pressing the amendment. Now, the Minister says she's carrying out a report. Now, Maynooth are carrying out a report, but not looking at the issues and the areas that I want to be looked at. You know, the financial impacts, the poverty impact. You know, the issues around homelessness. We know in August of this year, you know, youth homelessness has increased again. 893 people between the ages of 18 and 24. homeless, and the organisations representing our young people, the homeless organisations are saying, yes, these discriminatory cuts are adding to that. So it's very specific what I'm asking for, and Pathways to Work actually laid out clearly that such a report will be carried out back in Q2 of 2016, and well, it's not. It's being carried out by Maynooth, but it's not specific to the areas that I'm talking about. The report that's being carried out by Maynooth, and we've seen the drafts of that. It's looking at the impact, in terms of unemployment levels that these measures, have had. And Deputy O'Dea, when you're explaining the rationale as to, bringing in the discriminatory cuts, you're actually losing. The right thing to do now at this point is, to reverse these discriminatory cuts, and this will be, the evidence that we need, because all the evidence is out there by the organisations. But as I said already, our hands are tied because we can't bring forward amendments that will have a cost on the state. But the evidence is there. A report is needed, and I will be pressing this.
Before I come to you, Minister, Deputy Smith wanted to.
Yeah, well, Chair, I'm taking a bit of a liberty here, and it is a bit of a point of order. I want to support Deputy Brady on this, but clearly I've missed being able to move the amendment prior to it, number 10, and the one prior to that, number 9. And I just want to say, by way of explanation, that not being here was not my fault. I'm already, and all me bits and pieces together. The Business Committee have actually changed the order of business for next week to do with the legislation around the 8th Amendment, which I'm also very involved with because of our group is so small. So I had to go and have a discussion with our group to make sure that that is sorted out today. So this House has stopped me being able to put 2 motions, not my negligence or my lateness or my tardiness or anything else. So I'm asking you to allow me to put those 2 previous amendments.
We have disposed of the 2. They've already been put to the committee, the earlier ones. We're on everything prior to amendment.
But you couldn't have put 9 and 10 because I wasn't here to move them.
Because you weren't here, they fell.
But I'm asking you, can you take them?
They've already been disposed of in the sense that they fell. And I acknowledge...
We could pick them up again, couldn't we?
No. And to be fair, Deputy, I acknowledge the difficulties you have. I started the meeting by particularly asking if there were substitutes for anybody, because that is permissible, but there was nobody to move those at the point in the meeting. So we're on Deputy Brady's amendment, which is Amendment 11, and it is similar. I acknowledge it is similar. And if you want to contribute to that, before I go back to the Minister, no.
Could I just make a suggestion that you could bring them back at report stage, so it's not, I know we've already closed the sections, as in we've agreed them, and your bits weren't included in them, so we can't go back to them today, but you can bring them back at report stage.
Okay. All right, thank you.
And I'm sorry about it, Deputy. But
it was my own fault that I was, dying with a hangover. I missed the bus. I'd accept it, but it's this bloody house's fault that I wasn't able to be here.
I did deliberately at the start of the meeting ask specifically if there were substitutes for, because I'm mindful of the challenges people have with multiple committees and so forth.
Okay.
But that being said, you have that option at report stage. Do you want to contribute to Deputy Brady's?
No, I just want to back him up and support it.
Perfect. Minister, you were anxious to get back on amendment.
Thanks, Chair. And sorry, I didn't mean to interrupt. I just wanted to assure that you could bring them back again. I mightn't have been clear when I first made my contribution, so apologies if I wasn't. There is a study and a research piece of work that's been undertaken by the National University of Maynooth. The Deputy has alluded to apparently seeing drafts of it, which is more than I've seen, to be honest with you, but they are very, very close to publishing that research for everybody's benefit. That's nothing to do with me. It's not my report. I didn't commission it. It's not my research. It's nothing to do with the department. The department's document, the department's commitment that has already been made on numerous occasions, in public, in private, and it's in writing. We're ready practically to finalise our report that was made and committed under the Pathways to Work programme for 2016 to 2020, which will examine exactly what you're looking for today. So I don't have a problem committing, previously committing, recommitting. The report is very, very nearly ready to be published, and I'm very, very happy, Chair, if you want to come back here and this be the first place that we come back to and have a conversation about it. But I don't need to recommit in legislation to something that's already practically completed. And I can assure you at the earliest date that it is completed, we'll come back here and have a conversation about it. So I'm not against the report. I don't think we need to reinstate it in new legislation today for something that's already practically completed.
Mr Deputy Brady, brief point before I put this.
Well, Minister, I think it needs to be included because this sets a distinct time frame that it would be produced and brought before the House within 6 months. We can't allow this drag on, and unfortunately that appears to be the modus operandi of the department. This was committed to and it was supposed to be published in Q2 of 2016. That date was missed, and all the time youth homelessness is increasing, youth poverty is increasing. The impacts of these discriminatory cuts is having a devastating impact. 6 months will tie the hands of the department and ensure that this report is commissioned, carried out, produced and brought before the House. So
Brady, Minister, final comment.
Chair, just to say, I actually genuinely really enjoy working with this particular committee because the people are incredibly cooperative, and 99% of the time we actually all want the same thing, which is what makes it so enjoyable. And particularly if the country can deliver what we want, it makes it appreciative. You need to check your language, Deputy. Modus operandi of the department is to delay. Our aim is to tie people's hands. I'm sorry, that's not the department's the way it works, and I would ask you to withdraw the comments that you just made about 6,000 hard-working people who week in, week out work to serve the state. It's not on. It's not about political cheap shots.
It's not a slight on the individuals working on the department.
Well,
it's not a slight on.
Is it a slight on me, Johnny?
Well, you're the minister with responsibility.
So I have a modus operandi to delay and
why hasn't this report been published?
Deputy Brady, through the chair.
In 2016 it was
before we go, Deputy O'Dea, before we put this to...
Just ask the Minister 2 questions. The amendment says that he wants the report to concentrate on the financial, or to include consideration of the financial and social effects of this policy. So there's 2 questions, and he wants it published within 6 months. So there's 2 questions I want to ask the Minister. Will it include, the report you've done, will it include the financial and social effects that the reduced rate has had on the people affected, number 1? And number 2, can you give the committee a commitment that it'll be published within 6 months?
Minister.
The answer to the first question, Deputy, is yes, and I can probably tell you that the report will be issued in Q1 of next year. So all I'm saying is that I think we've gotten into the habit of putting reports into legislation in a manner that I don't think is required. We have a commitment to issue the report. I don't think there's any need for it, given that it's going to be published in Q1. But I'm not against the information. The information is going to become public, and I'm quite happy to come back here and talk about the outcomes of the report, Chair.
Thank you, Minister. Deputy Brady, are you pressing the amendment?
I am, President.
Okay. Section 11, Amendment 11, new section, that the new section be inserted. Those in favour? Those against? I think the amendment is defeated.
Vote all.
Vote all. Until the full membership is present before proceeding with the division. Elapsed. The doors shall now be locked and the division will be taken on the question that the new section be inserted. That's Amendment 11. A division has been challenged. Pursuant to standing orders, the division will now be taken by the Clerk of the Committee.
Minister. Chair.
Neil.
Deputy Neville substituting for Deputy Bailey.
Neil.
Deputy Brady. Deputy Farrell substituting for Deputy Carey.
Neil.
Deputy Collins, absent. Deputy Smith. Deputy O'Dea.
Neil.
Okay.
To Neil 5. The amendment is defeated. That Section 11 stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 12, Amendment 12. In the name of Deputy Bruin. As Deputy Bruin isn't here to move it, Amendment 12 falls. Amendment 13 in the name of Deputy O'Dea.
Yes, relates to cases of joint custody, where sometimes parents manage to have, in accordance with the terms of the agreement, that they have equal time with the child. In order to qualify for domiciliary care allowance, the relevant legislation and regulations provides that one of the parents, the applicant for domiciliary care allowance, must spend not less than 5 nights per week with the child. In practice, in some cases, this doesn't happen, and the amendment is designed to deal with that anomaly, because in those cases, and I have one particular one in mind, 2 people of joint custody, each spends exactly half the time with the child. Neither of them can claim domiciliary care allowance, which I think is very unfair in the circumstances.
Minister?
Can I say I totally agree with the Deputy, and I want to thank him. This is the second time he's raised this. He raised it in the Chamber the other day. I think there's an anomaly in the system, because DCA is a scheme that's working incredibly well, particularly after the reformation of the application form a number of years ago with DCA Warriors, and the tremendous amount of work that they put into making it a simplified scheme. It's now down to 5 weeks of a turnaround from application to receiving the award, and it's really, really working, and it's very, very positive. But you're right, Deputy, there is an anomaly. Under the conditions of the scheme, a parent needs to satisfy that they have a continuous period of 5 days caring over and above what normal parents do with normal, healthy, happy children. And we're all unfortunately aware that family life is different today than it would have been heretofore. So I'm asking the Deputy, would he consider withdrawing this amendment, just with a view to working with us for the next couple of days to provide a formula of words to do exactly what he's trying to do, so that we can recognise the caring arrangements of week on, week off, 3 days, 4 weeks, revolving, but just to ensure that if it's the child that has the care needs, regardless of who's providing the care, on a kind of a rota basis, that the DCA is actually awarded. I want to put a proper form of words to make it simple for us to administer. So if I could ask you to.
I appreciate the Minister's response, and the resources available to her are far greater than the resources available to me, so I'm happy to withdraw the amendment on that basis.
Thank you very much.
Chair, I'm sorry to interrupt you, if you could indulge me just for 1 second. And I know Deputy Brune is not here, and on that basis his amendment has been withdrawn. I just want to assure the committee, the legislation never had that particular word unforeseen in it. It was inserted in department guidelines for practical purposes a number of years ago, but because of a particular case, and I think we all know the case, that wording or set of words was removed from the guidelines by myself and the department in January of this year, and we now have reverted to the spirit of the legislation. So whilst Deputy Brune was attempting to do something, there isn't actually a need to do it. Those words have been taken out of our guidelines, and the practice has been reverted to individual deciding officers making individual assessments on somebody's presentable needs. So just to assure the Chair of the committee.
Thank you, Minister. Amendment 12 wasn't taken because the Deputy isn't here, and number 13 has been withdrawn by Deputy O'Dea. So at this stage then I put that section 12 stand part of the bill. Is that agreed?
Agreed.
Agreed. Section 13, Amendment 14, in the name of Deputy Brady.
Yep. Well, Minister, this amendment seeks to a review of the carers' allowance payment, given numerous issues that have been raised time and time again by carers here in this state. And the amendment in particular relates to priorities from the Family Carers Ireland in their pre-budget submission, which I'm sure you received and read through, Minister. And you'd be well aware of the issues facing carers right across the country, full-time carers who provide a phenomenal service, saving millions, if not billions, to the state on an annual basis in their caring duties that they provide. But there are huge implications, huge issues there for carers. You know, financial constraints. We know, you know, that they have to provide full-time care for a minimum of 35 hours a week, and they just receive a mere €16 additional on top of. You know, social welfare rates. So, you know, really providing a service for little or nothing. But they're prevented from working or studying for more than 15 hours a week. So, you know, they're not even able to complement that money that they're getting, providing that caring duty. So this report will be in line with what the Carers Ireland have asked for, and I think it would be hugely beneficial if that was carried out and brought before the committee here to have a look, to see what we can actually do to address the issues that carers have raised on a continuous basis. And I think the Minister needs to acknowledge the concerns of the carers, and she can acknowledge that by agreeing to this amendment and carrying out this review.
Deputy, before I come to you, Minister, there are one or two. Deputy Smith.
Yeah, I support this amendment, but I also think it would be a very, very useful report for us to have in general, because I mean, I haven't got the figures in front of me, but carers provide a huge amount of service for the state by providing full-time care at home. And if we took them, if we treated them better and took them more carefully and more seriously, I think we would get a lot more out of the population in terms of minding those who need to be minded. It's far better to be minded at home than to be minded in a healthcare facility or a hospital. I cared for my mum for a couple of years, and I was able to work 15 hours a week. I was doing some part-time work for my union at the time, tutoring, and it all worked out good for me. She has since died, but my sister cared for her then subsequently for about 15 years. And she's now in her early 60s, and she's nowhere to move, nowhere to go with her in the labour market. You know, she's just kind of discarded, and it's quite depressing for her. And I think it could tell us a lot about the role of women in society as well. You know, that it could have a more holistic vision on what we want to do for both women and for family carers, and for how it all impacts. And you know, I would be worried that people like my sister could suffer ill health because of the sense of, I'm useless now, nobody cares about me, having sacrificed that much of my life for doing something that's hugely valuable to society. And I'm sure the Minister recognises that value, as all of us do. But the consequences of not having the facts and figures and an insight into it, I think we miss out on something.
Deputy Smith. Deputy O'Dea.
Yeah, well, I'd be quite supportive of the last point made by Deputy Smith, because the fact of the matter is that 1 in 20 people in Ireland now is a carer, and the projections show that by 2030 that figure will have reduced, or will have increased, if you want to look at it the other way, to 1 in 5. Now, it is true to say that there's a huge amount of unpaid caring work being provided free to the state. I mean, the various figures have been bandied around, but it's a huge boon to the state, the amount of unpaid caring. Only 25% of people who are actually caring now are getting paid the carers allowance. That means 75% of people who are caring in the country at the moment haven't getting any payment for it, or any recognition as such from the state. And it's something, as I say, it's a rapidly growing phenomenon. It's something we have to come to grips with. And, you know, a report like this would certainly be useful in formulating policy in that direction, I think. You know, a number of points have been made to me, and a number of points have been made by Carers Ireland in their various submissions, which we all read. First of all, a carer, many of whom I know, and many of whom are working literally around the clock, have hardly time to go to mass. They're only paid €16 per week more. Now, granted, I know they're paid the annual allowance of €1,700, which, you know, would enable them to take a break for a very short time, which I can assure you in every case is very badly needed. You know, another point that has been made to me is the rigidity of the rules surrounding carers, you know, carers' ability to work. I mean, I've come across cases where, for example, somebody who is working on a flexible basis, sometimes they might be working 12 or 13 hours per week, which means they're within the requirements for carers allowance. Other weeks they might be working, say, 17 hours. But when you add it up for the year, and I've come across such cases, when you add it up for the year, you come in with an average of less than 15. Yet because they're working 1 week or 2 weeks more than 15 hours, they're debarred. I mean, I think that's wrong. Now, I know, I understand, I get it, that if somebody is awarded, is adjudged by the Department of Social Protection to be a full-time carer, there must be some restrictions on their ability to go out working. I mean, there are very few people who have the stamina and the energy and the time to be full-time carers and working at the same time. But what I'm saying to the Minister is there is a need for flexibility. There is a need for some flexibility, some discretion here. And I mean, you know, a report like as suggested here in the amendment could explore that, because I've done a number of case studies which show that as it's presently constructed, because of that 15-hour, the rigidity of that 15-hour rule, there's poverty traps that begin to emerge. I know some people, I have one person in mind, but I'm sure I have several others in my books, who came to me only in the last week, young, very active woman in her 30s, she's an SNA, and she is getting the carer's allowance for a disabled child, and she's working, taking on jobs, you know, as they're offered her, SNA positions as they're offered her. And you know, she's had to turn down work, even though she badly needs the money, and she could work, and she could because she's young, she's energetic, she wants to work, you know, as much as she can, and she would be able to work more and thereby increase the income, the family income, which is badly needed, but she's prevented from doing so by the rules. And there's another point also which I think is adverted in the amendment, that sometimes when you're caring for somebody, you know, say a middle-aged or middle-aged to elderly person caring for somebody else, when the caree dies, sometimes there isn't exactly an easy, recognisable pathway back into the workforce for that carer. So, you know, I think, on balance, I think a report along the lines suggested in the amendment would be useful. I mean, we have to formulate policy going forward because of demographics, etc. And I think, you know, we need all the help we can get. And I think if the department were to commission a report along the lines suggested, I don't know about the 3 months, whether it can be done in 3 months, but I mean, I'm flexible on that. But I do think such a report would be useful, and I think we should have one, quite frankly.
Minister.
Thanks, Chair, and thanks to the deputies for the contributions. I suppose there's nobody in this House, in either Dáil or Shannon Éireann, that doesn't recognise and appreciate the caring that's been given by friends, family members, people in our community up and down the country, and totally recognises that the country's common good couldn't survive without the thousands, if not millions of hours, I suppose, that are being given by those people to other neighbours and friends and family members every week and every year. The carers payment, I suppose, is unique insofar as that it's an allowance towards an income. It isn't a payment. I often wonder, in the last couple of years since arriving in this particular department, how it ever came about over and above the provision of actual services on behalf of the state, because that's the only reason it's in existence. It isn't an actual payment, because if it was a payment, we'd be paying pretty poorly for the amount of work that's been done, and I think that needs to be stated and recognised. The concern I have, and I'll ask you, and there have been changes made from our department in the last number of years. The income disregards have been increased. I know, Willie, you're talking about the rules, but there have to be rules, and so if it wasn't 15 hours, it'd be 14 or 17 hours. You know, there are rules for the reason. No, and I know what you're saying, but and actually I agree with it, to be honest with you. But we have tried to move over the last number of years to bring about different supports. We now have health and safety training, so we spend a couple of million euros every year trying to provide training courses and specific supports for carers around the country, so that they can improve their own safety and health and well-being during their caring years. We're now providing bereavement counselling after somebody who's caring for somebody passes away. And they're only small things, but it's just to try and appreciate and recognise that you need to wrap around and support these people. We also have special training in our intro services for, exactly as you, Bríd, had said, for somebody who's been caring for a number of years and then finds themselves isolated or removed from the workforce, and to try and help people to integrate them back into the workforce. But, Chair, I was thinking, like, I don't have a problem doing the report at all, except it might be kind of it mightn't be exactly what you're looking for, because I'm sure when we do the report, what we might come back and say is that the department is doing this, and this, and the Department of Health is doing this, and this, which isn't actually going to look at where the gaps are. And so I wonder, would you consider, rather than me or our department in isolation doing a report, that if we could have a series of hearings and maybe have a body of work that I will certainly contribute to in the JOC and have actual oral hearings and invite in not only carers associations and advocates but carers themselves to hear firsthand what it is that they're experiencing on a daily basis and what they'd like for us to do for them. And it isn't always just about increasing the payment from 200 and whatever euros it is each week. There are an awful lot more complexities around that. So, like, I don't have a problem doing the report, and I can bring, and maybe you're right, Willie, 3 months is probably pushing a little bit for us given that there's other reports to be done, but I think this mightn't work exactly the way we wanted to do in isolation, and I'd value maybe opening it up a little bit if that would be possible.
Minister, I mean, look, everyone around the room acknowledges the work that carers do, the savings to the state, and the issues that are affecting them. And what strikes me over the last number of years is the amount of young people now who are stepping in and providing that caring service for family members and that. And the restrictions there are impacting on them long term as well, because they can't study for more than 15 hours a week, and all of that needs to be looked at, the impact it's having, but also, long-time carers who might be caring for over 20 years, and the impact that's having in terms of their pension entitlements also. So all of that needs to be looked at. And Deputy O'Dea is right, we have the care support grant, but when you boil that down, that's only about $460, $465 a day. When you look at it, it is welcome. But when you boil it down, it's not even, the minimum wage, half of the minimum wage, a day. And I know the intention of that wasn't to provide a wage, but to give carers a bit of respite or whatever to help them with that. Now, the Minister says, yeah, the committee could do a piece of work on it, invite carers in and have a look at this from a holistic approach, and that would be welcome. But, Minister, the difficulty here is we've done that on numerous areas, lone parents. I mean, this committee, we went through an exhaustive process. We brought in all of the groups representing lone parents, and we produced a very, very comprehensive report which laid out clear recommendations as to how to address the issues facing lone parents. And that received support right across the Joint Committee. And unfortunately, the vast majority of recommendations coming out of that have fallen on deaf ears. So, whilst that approach would be welcome, having it not enshrined in legislation, that's where the difficulty is. So. I'm going to push this because I think we need to have it enshrined, because it will, I suppose, ensure that the report is carried out, and that doesn't preclude this committee, carrying out work in parallel to that. I acknowledge the time frame 3 months might be a bit tight. We can look at that, but I am going to push it.
Thank you, Deputy Minister.
I would say that the work that this committee did on lone parents was one of this committee's biggest successes, Chair, to be honest with you, because not only did we give a platform for lone parents to talk about the difficulties that they have, and particularly the prejudices that they face in this society. I would disagree with you, Deputy. The recommendations in the report were very, very loudly heard and heeded by the Department, and particularly since I came to this role a couple of years ago, because I think it revolves lone parents, children, in every single speech that I have made, in every single contribution that I have made in both the Dáil and the Shannon in this committee with regard to the difficulties that they faced arising from changes that were made in 2012, and the impact and the significant financial differences that the disregards have changed by in the last number of years, as recommended by this committee, as the qualified child increases warranted the improvements in the financial circumstances of lone parents as recognised by this committee. So I wouldn't put yourself down, Johnny. There was a tremendous amount of work done by this committee that was absolutely heeded by the Department and by me.
Don't be tempted.
Can I also say, Chair, I'm not sure what the Deputy wants. I mean, we'll do the report, and as I've said, 3 months is not feasible for me, given that there's other reports for us to do. There is only so many people can do reports in this department. Is your concern that if the Joint Oireachtas Committee does a report, that we won't listen to it? Because if that's the case, then you have exactly the same concern. If the department do the report, what do you think is going to be different if the department does the report or if the Joint Oireachtas Committee does the exercise? I'm not sure where your concern lies.
I'll come to you in a moment, Deputy Brady. Before that, Deputy Smith.
Well, listening to the discussion, I would think that we should do both. That the department should produce a report in line with the amendment. Because this request is very much based on financial and detail on financial and hours of work and stuff like that, where we could actually look at this issue in a more holistic way and invite in people like the Carers Association, Age Action Ireland, you know, various experts from different academic fields. We could do both. I don't see how one excludes or precludes the other.
That will be a matter for the committee to decide if they want to take it as part of their work programme. The way the amendment is drafted, it's to be presented and then the committee would decide, as is the normal course of events. Deputy O'Dea.
Just a technical question. As I say, I have no difficulty supporting the amendment. I'm just a little bit worried about the time frame. I mean, can you amend it to 6 months?
No, report stage. You can withdraw and resubmit at report stage with 6 months.
I certainly support it at report stage if the 6 months are free.
So you withdraw and resubmit at report stage with 6 months.
And resubmit it with 6 months, if in the understanding that we will receive citizen support. Otherwise, we'll have to push it. Just kind of respond to the minister there, just about the lone parents. Absolutely, some of the issues have been addressed, but one of the key recommendations in my view coming out of that report, and I have an amendment here around the child maintenance that I will be discussing now in a minute. One of the key recommendations was the establishment of a child maintenance service. You know, and I think that would deal with a lot of issues impacting on lone parents, and that was one of the key recommendations. And I know the minister will kick it over to the Department of Justice and say that's where the responsibility is for that. But that was
discussion in a moment. But in relation to Amendment 14, it's been withdrawn to be resubmitted with a 6-month period at report stage. So Section 13, that Section 13 stand part of the bill, is that agreed? There are no amendments to Section 14. That Section 14 stand part of the bill. Is that agreed?
Agreed.
No amendments to Section 15. That Section 15 stand part of the bill. Is that agreed?
Agreed.
Section 16, Amendment 15 in the name of Deputy O'Dea. The Amendment 15 is out of order, potential charge to revenue. So that Section 16 stand part of the bill. Is that agreed? Agreed. Section 17, Amendment 16 in the name of Deputy Brady.
Sorry, we've gone through Section 16, Amendment 17.
There was your Amendment 16.
Amendment 16.
Section 17, Amendment 16.
Okay, yeah.
Yours.
Yep,
yeah.
Amendment 16. Yeah, this is... It's asking the minister to engage with all the key stakeholders to ensure when we come to, on an annual basis, setting social welfare payments, to ensure that they're evidence-based, that they're based on adequacy for recipients. And every year we seem to get to a point where the setting of the rates, it's a political football. And the approach, a fiver for all. It's not looking at how adequate the payments are. It's not based on evidence. And it's really a political football, and we see that over the last number of years. So. There needs to be, evidence. It needs to be evidence-based, and the minister would be aware that I've produced a social welfare commission bill, which would actually take the setting of the rates out of the hands of the department, given over to the Social Welfare Commission bill, who would look at this whole area, engage with all of the key stakeholders, ensure that the increases are evidence-based, they're based on adequacy for recipients. So, this amendment simply asks the minister to meet and engage with all of the key stakeholders on ways in which we can ensure that actually happens.
Thank you, Deputy Minister.
Thanks, Chair. Every summer, the Department, and it predates me, has a pre-budget forum in Dublin Castle where we listen to the views of some 45 different representatives of community, voluntary and the employer representatives, and they talk about their priorities and wishes for the following budget that year. And the priorities that emerged from this consultation this year included a higher rate of payment for dependent children of age 12 and over, which was a message that was given to us very, very loud and clear, and we were happy to look at. But establishing a benchmarking social welfare rates did emerge from a number of people at that committee that day. And the Budget 2019 €5 increase is the maximum weekly rate of social welfare payments for pensioners, for lone parents, for people with disabilities, workers on maternity or paternity leave, job seekers. They're all above an inflation rate increase, and thankfully that's for the third successive year in a row. As I stated on Budget Day in my speech, now that the core rates have been in the main and largely restored, I think it's time to fundamentally examine the way in which we approach the business of setting our rates on an annual basis. And so I think the Deputy might be surprised to hear that I very much agree with them. Chair, a number of other countries have shown us that by doing this and instituting a process of benchmarking, that welfare rates typically use a system where the core rates are fixed each year with reference to either market earnings or particular price levels, indexes, and I think it works very, very well. And indeed, actually, on a very snowy day, I think it was in March this year, when we launched the roadmap for pension reform, the government already committed to adopting exactly a benchmarking approach in respect of pensions. And I indicated on that day that we would develop proposals to deliver this commitment before the end of this year, and we're still on target to do this. But my own personal view, and I said this in the Chamber on Budget Day when we were having our second stage speeches, that I have a view very much so that we should do this and extend this to all core welfare rates. I think if a system is implemented, it'll provide the context, the framework, and it'll both be informed and measurable, and probably most importantly, it'll be evidence-based as to why we reach a determination on what a new social welfare rate should look like. And to give you and cite an example, I know there are some concerns that it might bring us to a new level of both having an evidence-based measure input into the determination of what a welfare rate is, but also a political input over and above on top of that, so as not to have one new system. We might have an amalgamation of what we currently have and an evidence-based systems and arrive at maybe better payments. But I think the system that we have with regard to the Low Pay Commission that was established a number of years ago works incredibly well. The establishment of that particular body, the composition of both employers, employees and independent people, and how we respect and carry out their wishes on an annual basis in the Dáil and the Seanad, I think is a real good model that we could look at going forward. So I'm very, very happy to say that this amendment doesn't really fulfil, I suppose, what I think the Deputy wants to do. He wants me to consult. We already do that. I don't need to be told in legislation to do what we do. We do it. But what I think would be a hugely worthwhile exercise is for us to move towards establishing a body to actually do a proper analysis on what welfare rates should be every year, and to be mindful of that. So I'm happy to accept this amendment, Chair.
Deputy O'Dea.
Just a brief comment. I'm heartened to hear what the Minister says, because her predecessor in that job, who is now Taoiseach, seemed to be for a long time wedded to the idea of linking social welfare increases to inflation. You can't simply link social welfare increases to headline inflation, because numerous studies have shown that for people who are wholly or mainly reliant on social welfare, a different rate of inflation applies. They spend their money on the necessities of life, heating, food, etc., where the inflation rate has far exceeded the overall inflation rate, which includes the cost of yachts and Ferraris, etc. So, you know, some formula has to be worked out. So I'm glad now that the Minister is thinking in that direction.
Deputy Brady.
Well, I'm happy the Minister is going to accept this amendment.
She is.
Yeah, so I welcome that, because we need to move away from the system for all of the reasons that I have outlined, and you know, all of the organisations out there, and you know, more importantly, people you know, who are in receipt of payments right across the board. That absolutely, it shouldn't just be you know, pensions. It should be all payments. You know, and everyone wants certainty. You know, and there's phenomenal work going on by, you know, the likes of the Vincentian Partnership, who, you know, on an annual basis do phenomenal work there, looking at minimum essential standards, and all of that needs to be taken on board by the Minister. I'm heartened to hear that she's referencing the Low Pay Commission, because the Minister would be aware that the legislation that I've brought forward, the Social Welfare Commission, it is based on the Low Pay Commission, set up more or less on the same. The makeup of that commission would consist of 9 members, taking on all of the evidence, all of the information carried out by all of those organisations, and we need to move to that system. So, I asked the Minister as to whether she has looked at that legislation, because I think that would be the basis to move forward. And I can only take her at a word of what she's saying. She wants this to be put in place. She wants to make the changes. She needs to give serious consideration to the legislation that is there already. There's been exhaustive work carried out on it. A lot of engagement with all of the organisations.
Stay with the amendment.
Absolutely, but I think it is important as well. So maybe if she would just make a comment on that, because broadly all of the NGOs out there, all of the organisations that I've engaged with support the establishment of that commission. I know it's moving a bit away from the amendment, but it does cut to the heart.
Minister, do you want to comment, or do you want to say
the amendment?
Let's stay with the amendment. Minister, just one comment from myself in relation to the amendment. It's all fine benchmarking the increase in payments, but it's also important that, and I mentioned it at second stage, that there's a whole of government review in terms of income thresholds for grants and other schemes that are then affected by these increases, and that needs to be included as part of the overall. In terms of Amendment 17 in the name of Deputy Brady, that's been accepted by your pressing, and it's accepted. So that's agreed.
Amendment 16, isn't it?
No, Amendment 16 is accepted. So that Section 17 now stand part of the bill. Agreed. Section 18, Amendment 17, Deputy Brady.
Yeah.
Amendment 17.
Yeah. So this is just around the child maintenance being used as part of means for social welfare payments, and I have, myself and the Minister, we have spoken about this on the floor, the chamber, so it's really pushing that whole area. It shouldn't be seen our means tested, so I will be moving this amendment.
Minister.
Yeah, Chair, I'm not proposing to accept this amendment for a number of reasons. First of all, the Department doesn't distinguish between child maintenance and mammy or daddy maintenance. I don't know what you call adult maintenance, sorry. The purpose of means testing social welfare payments is to ensure that the targeted resources that we have hit the targets, as in the people who need them the most. And social welfare legislation provides for the means testing of social assistance schemes to take into account all income into households and all assets belonging to the people that are looking for the support of the state. And it has to be applicable that maintenance, which is income into a household, has to be seen as that, as income. And so we don't differentiate between child maintenance or adult maintenance. But what we very much do recognise is that there is a cost associated with providing a roof over your head, and that's why there's an income disregard of €95 per week towards housing. And then whatever left in the maintenance payment is divided by 50% before we then take the remaining portion as reckonable income into that household. Because I think what the Deputy is attempting to do is that we consistently, and he has ironically, he has an amendment coming later on in the bill to ensure that errand people who aren't paying financially towards their children, that we produce a system in this country to make it easier for parents, and it's particularly mostly in the main women who have to chase for maintenance payments, to make that easier and make it more efficient and put a legal basis on it, which I know other people in this chamber have an interest in. But at the same time, when somebody does make a payment towards their child, he thinks the state should disregard that payment as if it wasn't being made, and so therefore diminishes the value of the parent parent who is contributing towards their child's upbringing, support, care, maintenance, and kind of discounts it. So on that basis, look, the Revenue Commissioners, the state, the laws of our land indicate that income is income. What we've tried to be is as flexible as we possibly can when determining disregards of that maintenance income into a household. And as I said, we have what the Department believes is a fair system currently at the moment, but it also recognises both parents' contributions towards the upkeep of their children.
Deputy O'Dea?
I'm a small bit confused now. I mean, sorry. Surely the amendment just looks to Commissioner report. I mean, I don't think Deputy Brady is proposing well, he's not entitled to propose disregard of maintenance payments. He's simply proposing a report. I mean, is there any? I don't see any great difficulty with that, really. I mean, again, he's a fairly ambitious time frame in there, but nevertheless, it is a problem that has been hanging around for some time. Can I just say to the Minister, there seems to be some sort of a misunderstanding here, and I mean, I think she kind of misunderstood what I said as well at second stage. You see, at the moment, there is a disregard for a certain amount. I think it's €97 or something, for 95, sorry. Just a few questions on that. I mean, you see, what the point I was trying to convey, maybe badly at second stage, was that the rates of poverty amongst lone parents are dramatic, pretty dramatic. I mean, deprivation levels over 50%. So, you know, if you had a situation whereby you didn't count maintenance, you disregarded maintenance in the calculation, say, of lone parent allowance, that would mean that that family would be €95 a week better off. Surely this is the sort of targeting we're talking about. If you want to lift...
They are €95 a week better off because it is disregarded.
Sorry, the balance. They'd be better off by the balance then, okay? By what you're counting. They'd be better off by what you're counting. Do you follow? Their net income would be more. Their income would be more because the maintenance would be entirely disregarded. Sorry. So isn't this, you know, the sort of targeting we're talking about to lift that particular sector? I mean, if you want to focus on poverty in this country, look at people with disabilities, look at lone parents. I mean, they're the two groups that stand out particularly in terms of the statistics. And by disregarding maintenance payments entirely, you actually increase the level of income of these very low income families. So, you know, that would be a very good targeting measure. I don't know what it would cost. In practice, I imagine to be very small in the overall context. Now, the other thing is that, can I ask the Minister, I mean, some people in the department, I don't know whether it's still official policy or not, but some people in the department seem to be of the view that if a woman, and usually it is a woman, goes to court and goes through all the hassle of getting a maintenance order and all the confrontation, etc., and somebody isn't paying the maintenance, they're not obeying the order, why does the department insist on assessing that as income? I mean, like, in practice, it only deters people, it discourages people from seeking maintenance, because you know, you seek maintenance. Your lone parent allowance is either not payable at all or payable in a diminished form, and you mightn't be getting the compensating payment, because sometimes very hard to get money out of some of those people, and surely that's the deterrent to seeking maintenance in the first place. And finally, can I ask the Minister, where are we with the maintenance recovery? There has to be, I mean, I think, you know, all independent observers, leaving politics out of it, all independent observers are of the view that some sort of an independent maintenance recovery agency is now, it's now absolutely necessary. And I'm just wondering where we are exactly with that.
Before I come back to you, Deputy Brady.
Just a couple of points there. And myself and the Minister will probably never see eye to eye on this, because I think if you have a look at the stats, and Deputy O'Dea is right, you know, people with a disability and children in lone parent family, I mean, they're, you know, two of the categories where we have the highest poverty levels, and the difficulties here for one parent families, you know, even to try get maintenance in the first case, and I'll try to touch on that now in a couple of minutes, you know, but the fact that maintenance is taken as an income, and there's difficulties there where, you know, maintenance is awarded and then not paid, and then there's difficulties that it's still taken as an income, even though the parent isn't actually receiving it. So there's huge issues, and I think having a report carried out and laying out clearly the impact it's having on parents and children in those situations would be very, very helpful. I acknowledge the time frame might be a bit tight in that, but certainly I will be pushing this.
Minister?
So to answer two questions from Deputy O'Dea. First of all, it isn't anymore. I know it used to be, but the practice was changed earlier on this year for a number of reasons. I think we started looking at particularly lone parent families and the conditionality that was set and some of the precarious situations that it was putting some women in. We addressed that situation. And we also looked at I suppose the practice, and it wasn't in every part of the country, where some people were including the promise of a payment of maintenance in the overall assessment of means of an income or of a household. Promise me we only deal in hard facts now, so if there is no payment, then it's not. You can't have a disregard for something that isn't coming into somebody's back pocket or into somebody's household. So the practice has changed there. And I think, as you and I had a conversation last week about our own involvement from a department in maintenance recovery, I'm conducting a review that I'm very close to finalising at the moment as to what our input should be and what the conditionalities, particularly around lone parents and one-parent family payments, should be. And I would expect to have that maybe earlier in the new year, and then to make determinations as to if we're in, we should be all in. If we're not in, then we should be all out, and I value maybe your advice on that when we come back with the report maybe after Christmas. Chair, I come back to, I'm not in a position to accept the amendment for number one reason. Well, there's two reasons. Number one, there is no such thing as child maintenance. When court orders make court orders for maintenance, they make it for maintenance. They don't make it for children. They don't apportion. So for argument's sake, if there's a maintenance order given of €200 a week, they don't say that €27 is for the mammy and the other 100 and whatever is for the children. They make an maintenance order against the parent that's not living with the children. It would be very difficult for me to determine the impact of what the Deputy is trying to do on child maintenance when there is no data around that. That's the first thing I'll say to you.
Can I interrupt you for just one moment? Deputy Brady, you're leaving, are you?
Are you
leaving immediately?
So.
Are you leaving? I just want clarity for Deputy Brady. Are you leaving immediately?
I'm leaving, but I just am pressing it, and Deputy Kenny is stepping in.
Can I ask you specifically, because I will be putting the amendment in your absence, so there's clarity. A previous amendment you withdrew to resubmit at committee stage because you wanted the 6 month rather than the 3 month. Are you and your colleague pressing the amendment as is, or are you withdrawing to resubmit with the 6 months? Just so there's clarity when you're gone.
If I can get clarity, if I can get support that if I withdraw it and resubmit it at report stage and change the time frame to the 6 months from 3 months to 6 months, you know, and if there is agreement on that, I will withdraw it and resubmit it with a 6 month time frame.
Sorry for interrupting. I'll come back to you, Minister. Just Deputy Brady was leaving, and I wanted to be fair to him. Deputy O'Dea, Deputy Penrose.
Yeah.
Yes. Sorry, Deputy Penrose.
Sorry. You know, this is an interesting argument, Minister. I'm a bit taken aback by somebody who practices in the court of maintenance. Of course, it has to be child-related, because if you go in there for maintenance as an individual spouse, you're going to be ordered €80 or €90. And then they look at the children. This is what we have to do outside it, even when we're bringing in a judicial separation, because that's proper provision. So you have to argue then, the child might be €30 or €35. So it is severable. But the big thing that I have, and the argument I have, is that very often, even getting court orders, Chairperson, and everything is in place and everything's there. So I'm the judge, I ordered Mr. O'Dea to pay XU, and why? That collapses after a month or 6 weeks. And so therefore you have it built into the assessment, and it's there, and then you say, oh no, that's grand, Mr. O'Dea didn't pay his money. And what is, you say to Mrs. O'Dea, you could come in back into me, and you go through a process with yourselves that starts it all over again, and in 4 months' time, they still won't have a penny. So grab the ball now, because you are innovative, I'll say that much. Grab this ball now, and maybe in this review, make sure that that's incorporated. Look, the head, and they say down in Westmeath, and it's only across the road from yourself, the head isn't worth the wash. Going after this, the head isn't worth the wash. So look, do this, and it'll cut out this nonsense. Keep away from courts and stuff like that. You're dealing with a social protection system. People who are in this position are vulnerable anyhow, and they're down as struggling. So I think myself that this is an important, and I think if Deputy Brady even wants to bring in those at home, he can leave out the word child. Just put maintenance, and away you go, and it's 6 months, and I think this will be a valuable report.
Deputy O'Dea.
Yeah, I'd be inclined to take the same view as Deputy Penrose. I think that if you're prepared to bring it back at report stage with 6 months instead of 3 months, I think I can support it, yeah.
Minister, do you want to comment?
Again, I would ask, I mean, again, if it's a report, I have to do it, I do it, it's no big deal. You need to remove the child maintenance, as Willie Penrose has suggested, if you don't mind. It would be impossible for me to do it otherwise. So.
Deputy Brady, you've heard the consensus of the committee. Are you prepared to withdraw and resubmit?
I'll withdraw it and resubmit it at report stage.
And maintenance in 6 months.
Yeah, okay.
You have it, Deputy Brady. Okay, thank you. That's Amendment 17 is withdrawn to be resubmitted at report final stage. Amendment number 18 in the name of Deputy O'Dea is out of order. Amendment 19 in the name of Deputy O'Dea is out of order. Amendment number 20 in the name of Deputy Brady is out of order. Amendment 21 in the name of Deputy O'Dea is out of order, 22 in the name of Deputy O'Dea is out of order, and 23 in the name of Deputy O'Dea is out of order. Therefore, I put Section 19, that Section 19 stand part of the bill. Is that agreed? Agreed. Section 20. Amendment number 24 in the name of Deputy O'Dea is out of order. Amendment 25 in the name of Deputy O'Dea is a new section. Deputy O'Dea, Amendment 25.
Yeah, well, this just goes over what we discussed at question time last week. The effect of Brexit in the social welfare area is giving rise to some concerns. I mean, there's a lot of people, I gave the numbers last week in the Dáil, a lot of people who are Irish residents who are receiving social security payments in the British government and vice versa. And I just want to make sure, the Minister has assured us that this problem is being considered in depth within the department, and that various scenarios, etc., are being looked at. And I just want to ensure that when that analysis, when that study is completed, that we'll be all getting a look at it.
Deputy Minister?
That's fine.
Deputy Kenny, anybody want to comment?
Yeah, just briefly, thank you, Chair. Deputy Brady tells me that he has raised this through PQs on a number of occasions with the Minister, and he says here, we note that these payments are to be protected according to the withdrawal agreement, as is, and this is welcome, but we need absolute certainty on this, and that there can be no limits on this. Not just pensions to be considered here, but also secondary payments, additional payments to that, and it should go without saying that this analysis will be shared, and if the Minister can confirm that it will, then we'll be happy to take our word on it, that we feel that this is something that can be sorted out pretty easily.
Okay, thank you. So Section 25, the new section be inserted, that Section 25, or Amendment 25 is being put. Are those in favour? Agreed? Agreed. Section 20, Amendment 26 is out of order in the name of Deputy O'Dea. Amendment number 20.
Well, can I just comment briefly on that?
You can, but it's out of order.
Very briefly, so I'll be exceptionally brief. The Minister will be aware that in some parts of the country there are more TUS workers on schemes now than CE workers. Now, some concessions and flexibility have been extended to CE workers in relation to extension of their time. I mean, it seems illogical now that same concession wouldn't be extended to TUS workers. I know that strictly the amendment is out of order because technically it puts a charge in the Exchequer, but I really think that, you know, in the interest of fairness, in the interest of keeping some of those schemes going, etc., that one should be treated like the other.
Mr. Deputy O'Dea recognises he's out of order, but do you want to comment on the point he made on that amendment?
Not really. I'm not sure how I can help or be of any help. I mean, the two schemes are very, very different, Deputy, and I think if we had a whole load of schemes with exactly the same rules and exactly the same potential outcomes, well, then you'd have to question why we have a whole load of schemes with exactly the same rules and the same outcomes. So TUS has a particular remit, and CE have a different remit, so that's why they have different rules.
Thank you, Minister. Deputy, you'll have to find another way of dealing with that issue.
I mean, it simply means that an increasing number of schemes who are reliant mainly on TUS now won't be able to continue. I mean, that's the reality of it.
Unsympathetic to the issue, but it's not being dealt with in the bill. That Amendment 26 is out of order. Amendment number 27 in the name of Deputy Brady is also out of order. Amendment 29.
Can I just say...
On which amendment now?
Just briefly, because I missed out. I got delayed this morning. But Minister Doherty did announce, or did indicate to me in the Dáil that an issue that I brought to her attention, it got to do with this pension thing. That persons born after the 1st of September 1946 would have a review of their pension titles. You know, the changes brought in under the Social Welfare Bill, welcome, there they are, on 6th of April 2012, double the number for those people after 6th of April 1946. But on this basis, you know, the review that you're taking place will take place on the 6th of April and not from the 1st of September. So, I mean, I'm asking that you would take cognizance of this. And you were to come back to me on it, and I know in fairness you always come back, but the 6th of April 1946 versus the 1st of September 1946, there's only a very small number of people. Yep. You know, it'll be very little, and I'd ask you just to try and review it for report stage, because if you don't put it into the legislation in some shape or form, we'll be dead in the, and you'll tell me, oh, we didn't do it. So my apologies for not, I was 5 minutes late with the amendment, to be honest.
No problem. And actually,
it was a very hard case.
Yeah, no.
Minister.
Just to confirm to the Deputy, because he did raise it with me in the Chamber last week, and I know Deputy O'Dea did too. The only reason I don't have an amendment is because I'm not 100% sure of the dates yet. I will have an amendment for report stage, and if what you've said is true, then we will bring our own amendment. So you don't have to worry. If it needs to be fixed, it will be fixed.
I'll just leave you with a note there, even from a woman who contacted me. So.
Great. Yeah, but just be absolutely assured that if the dates need to change, we will bring our own amendment.
Yeah, it won't cost an arm and a leg. That's the only good thing.
Thank you, Deputy Penrose. So, Amendment 28 in the name of Deputy Claire Daly is out of order. Amendment 29 in the name of Deputy Brady is out of order. And Amendment 30 in the names of Deputy Bríd Smith, Gino Kenny and Boyd Barrett is also out of order. Therefore, that Section 20 stand part of the bill. Is that agreed?
Agreed.
No amendments to Section 21. That Section 21 stand part of the bill. Is that agreed?
Agreed.
No amendments to Section 22. That Section 22 stand part of the bill.
Agreed.
No amendments to 23. That Section 23 stand part of the bill.
Agreed.
No amendments to Section 24. That Section 24 stand part of the bill. Is that agreed? Schedule 1, no amendments. That Schedule 1 be a schedule to the bill. Is that agreed?
Agreed.
Schedule 2, that Schedule 2 be a schedule to the bill. Is that agreed?
Agreed.
That Schedule 3 be a schedule to the bill. Is that agreed?
Agreed.
And then that this bill be the title to the bill, an act to amend and extend social welfare acts, to amend and extend the Pension Act 1990, to amend the Civil Registration Act 2004, to amend the National Training Fund Act 2000, and to provide for related matters. Is that agreed?
Agreed.
In accordance with Standing Order 90, the following message will be sent by the Clerk to the Clerk of the Dáil. That the Select Committee on on Employment Affairs and Social Protection has completed its consideration of the Social Welfare, Pensions and Civil Registration Bill 2018 and has made the amendments. I would like to thank the Minister and her officials for attending the proceedings today.
Thank you, Chair.
And as there are no further items, that concludes the business.
Thank you.